All right, Dave, if you want to get started.
Sure. Good evening, everybody. Thanks for joining us. Pardon me sipping on my tea, just recovering from a bit of a sore throat. So I'll be kind of massaging my throat as we go through this webinar. Great news, you can't get a cold through a webinar, so you're all safe. So welcome to How the Secure Act Changes the Way That You Plan for Retirement. My name is David Nader. You'll meet my partner, Eric Greco, in a moment. We're with Greco Nader Wealth Navigation. And our goal tonight is to give you some information on this fairly new tax law change that just came out. It's been enacted about 5 weeks now. A little bit about us. We're a family-owned wealth management firm. We specialize in retirement planning. We specialize in helping people retire. Okay. My partner Rosario is a CFP and a CPA, father of 3. Myself, I'm a father of 2. I'm also a certified financial planner. Between Rosario and myself, we have 60 years of helping people retire, and not just in New Jersey. At this point in time in our careers, half of our clients are in New Jersey and half are out, whether they were clients who already lived in Texas, California, Oregon, what have you, or lived in New Jersey and then left once they did retire. But we've been doing this between this for about 60 years. So we hope to give you some good information tonight. So what are we going to talk about today? We'll talk about what the Secure Act is. It was part of the recently passed spending bill. It was passed on December 20th. We'll talk about who it affects, what is the required minimum distribution age increase, okay? We'll talk about some tax reduction strategies to overcome the increase in the required minimum distribution age, whether that be Roth conversions. We'll talk about qualified charitable distributions, okay? We'll talk about the stretch IRA rule changes. Used to be you could stretch an IRA to the beneficiaries over their lifetime. That's changed. Now, what can you do to combat that? Some strategies. We can split beneficiaries, can use life insurance, we can use charitable remainder trusts. And then there's some other changes we'll talk about, and then we'll have a bit of time for questions and answers as well in terms of at the end of the session, okay? So there's some new tax forms with this tax law change. This is the new simplified 1040. You put in your name, address, zip code, social security number. Line 1, what did you make last year? Line 2, just send it on in. Now, we're making a joke. It's a tax code. We're trying to keep it a little light, but we'll try and give you some decent information without being too dry in terms of what we're presenting to you, okay? So what is the Secure Act, okay? As I mentioned, and I'm just moving something here. So, excuse me. Setting every community up for Retirement Enhancement Act of 2019, voted on in the Senate, signed into law by the President December 20th, 2019. Okay, so again, very new. It's one of the biggest changes to financial and retirement planning in a decade. You've got new challenges, but there are also new opportunities, and that's what we're going to try and address with you tonight is what are these new opportunities? These are the main provisions that you see on the screen before you. We are not going to go through all of these. These green arrows are going to highlight the ones that we're going to try and concentrate on with you. Okay. In terms of the IRA rules, there's the elimination of the lifetime stretch provision for non-spousal beneficiaries. It used to be that your children could inherit your IRA and stretch it out over the course of their lifetime. That's no longer the case. Between spouses, you do still have that stretch capability. Okay, required minimum distributions used to be started at 70.5. It's now at age of 72, so you can start them a bit later. They removed the age 70.5 limitation on contributions to IRAs. So for our clients who they've retired but do consulting work, other work, if you're over 70.5 but have earned income, you can still make a contribution to a deductible IRA, which is great news. There's a $5,000 qualified birth or adoption distribution allowance. Taxable non-tuition fellowship and stipend payments are treated as compensation for IRA purposes. And lastly, non-deductible IRA contributions can be made with certain foster care payments. In terms of the main IRA provision that we'll want you to be aware of, IRAs now have to have, under the ERISA rules, a safe harbor for selecting an annuity for retirement plans. So not just a large lump sum that goes into an IRA, but you can select it as an annuity instead of a monthly income stream for yourself in retirement. Other provisions, there's a qualified education expense for 529 plans, and that's now expanded so that you can use it to pay down student loans and pay down student loan debt. Okay. Now, who's most at risk? Okay. Anyone with a large 401k or a large traditional IRA. Now, caveat, do not look at that and say, hey, I should stop putting money to my 401k. It's not what we're saying here. We're simply alerting you to the fact that if you do have a large IRA or a large 401k, there's some things you need to be aware of. It's not uncommon now when you have a husband and wife both working. The 401k has been around for decades now. And we're seeing people in their 60s now approaching retirement where it's not uncommon, husband and wife both working, continually contributing, taking care of match contributions, taking care of catch-up provisions, and investing in equities to have an IRA approaching $1 million or multi-million-dollar IRAs between husband and wife. So you want to pay attention if this is your situation. If you're a single person or a widower with a large IRA balance, you're especially at risk because most of the things that we're going to talk about take effect when the IRA goes to the next generation. Between husband and wife, I can still leave my IRA to my wife and she can stretch it out over her lifetime. If you're a couple age 65, and actually, Marissa, why don't you do a poll? Find out who's retired and who's pre-retirement, just so we kind of get a sense we can maybe direct some of the content more to pre-retirees versus retirees, and we'll see how that works out. If you're age 65 today, husband and wife, statistically speaking, there's a 50% chance that one of you is going to live to the age of 95. Okay, so between the two of you, between husband and wife, you can still stretch out this IRA over the course of your life. Most of the provisions we're going to talk about, the loss of stretch goes when it goes to the next generation, to your children. Okay. Also, if you're concerned about the after-tax value of the IRA that goes to your beneficiaries, this is going to be something that's going to be of interest to you. And lastly, if you have your primary beneficiary as a trust, because those rules would have been affected as well. So the potential impact, this is estimated, this is a revenue grab by the Internal Revenue Service, okay? A lot of plans that need to be paid for, a lot of spending things, and that's what this is. It's expected to bring in about $16.3 billion to the US government. What they're doing is they are accelerating the period of time that your beneficiaries take money into income. They're making it that they've got to take it into income sooner by reducing the stretch. It's going to generate tax revenue. If you've done estate planning in the past, that would probably need to be revisited at this point in time. Okay, whether you use just beneficiary designations or you use trusts, asset protection trusts, things of that nature. You want to pay particular attention if you've got children who are financially successful in their own right and who live in a high income tax state. New Jersey's one, New York is one, California's one. If they're in Florida, there's no state income tax. So your beneficiary's own personal financial situation can play somewhat of a role in how you design your estate plan and leave assets to the next generation. If you leave large IRAs to your children, it could decrease your children's ability to qualify for financial aid for their children, your grandchildren. If you try and leave an IRA directly to your college-bound grandchildren, they'll be subject to the kiddie tax, and they'll pay income tax at the parents' income tax rate. So we'll talk about some tax reduction strategies for you. How to use Roth conversions in years where your income tax is low, where your income is low, and you can take advantage of being in a lower tax bracket. We'll talk about ways to manipulate legally your income by where do you take assets from, IRA or non-IRA sources. Do you delay taking a pension? Do you delay taking Social Security? We'll talk about when to start distributing from your IRAs, and again, how to leverage tax brackets. There are many ways to legally manipulate the income taxes that you pay. We'll talk about how to split your beneficiaries to reduce the tax obligations that they would pay, and how to take advantage of the tax bracket during your gap years. We define gap years as between the time that you retire and start collecting Social Security or start collecting your IRAs. You can, again, control when you take money into income and hence manipulate what your tax bracket is. We'll talk about how withdrawing from IRAs at lower rates and potentially purchasing a life insurance policy could be used to offset the tax liability that your beneficiaries will pay when they inherit these IRAs. We'll talk about why qualified charitable distributions can lower future required minimum distributions prior to your age of 72. And lastly, how you can use charitable remainder trusts to lower your tax bill if you're charitably inclined. So the RMD, which stands for required minimum distribution, that's the point in time when you have to start taking money out of your IRAs. So you've always been forced to take money out of the IRAs. This is going to accelerate it for your beneficiaries. The withdrawal age for the IRA owner has been changed from 70 and a half. Now it's extended out to the age of 72. If you were taking your required minimum distribution prior to this law going into effect, you've now got to continue. You cannot stop and then restart at age 72. Okay. So what this is showing you, the old trigger, as you see there in red, that red circle, was 70 and a half. Okay. The new trigger is the age of 72. Okay. You can extend out, in this example, if your first RMD should have been taken by April 1 of 2022, now it's got to be taken by April 1 of 2024. That's for someone who was born in March of 1951. So it has been extended out, but you do still need to take it. So let's look at a quick example. Okay. Sully is a traditional IRA owner, born on June 3rd, 1950. He'll turn 70 and a half on December 3rd of 2020. Prior to the changes made by this act, he'd have needed to start his required minimum distributions in 2020, or as late as April 1st of 2021. In light of the changes to this with this act, he will not have to begin taking distributions until the year he reaches 72, which is in 2022. So his first required minimum distribution could be as late as April 1st of 2023. So again, his RMDs can be delayed by 2 years.
Okay, Dave, thanks. We're going to talk a little bit about now, I'm Rosario Greco, I'm part of Greco Nader. We're going to talk about a tax reduction strategy called a Roth conversion. But before I get on to a Roth, I just want people to understand the main grip of this Secured Act is basically that we took away the ability to stretch out over your kid's lifetime these RMD distributions. So instead of having a stretch of 20, 30, 40, possibly 50 years, the new law requires for a non-spouse beneficiary to take it over 10 years. Now think that out. If I have to take it over 10 years and not 30, 40, 50, the amounts are greater. They get added into the income of your kids. And the taxes or the tax bracket might be way higher. Thus, the taxes paid would be greater. So what is the solution to this, to these RMDs? So first we have to understand the gap years, and Dave alluded to this a few moments ago, and where a gap year is we retire, let's say 62, and the RMD is now 72. So we have 10 gap years. Why the gap years are important is to take a Roth conversion opportunity when you get into the RMD, meaning at 72, you have to take the 72 RMD first. Then after that, you can take the Roth, which means you can't use those RMDs at 72 for Roth conversions. You have to take them. Then if you want to do a Roth, take out more, which now will get you into a higher tax bracket. So these years before you get to your RMD age of 72 is very, very important to possibly use a Roth conversion. An example of this, just in looking at tax rates, is if we look at a non-Roth situation where I have a couple, 63 years old, they're getting a pension of $100,000, they're retired. Their marginal rate right now is 22%. If they had $2.5 million between them in their IRA and that grows at 7% over the next 9 years to get to 72, they would have roughly about $4.5 million. Well, at 72, the $100,000 pension is still being paid. Social Security now comes to play, $60,000. The RMD, which is 4% roughly of that $4.5 million amount, IRA amount, is now $180,000. You add that all together and your tax return is going to show 340,000. Well, at 340,000, you'll be at a 32% marginal rate. So you can see there's a pretty large jump here on what taxes have to be paid if you wait and act later on taking out money from your IRA. Now, solution to this would be, why don't we just create a Roth? And that is a pretty good solution for most folks. Again, the same facts, 63-year-old couple, pension 100,000, 22 marginal rate. Now what we're gonna say is, okay, we're gonna take some money out every year from your IRA for the next 9 years to convert it into a Roth. Well, how much money? Well, the current tax brackets, a joint or a couple in a joint return, you can go up to 326,000 as taxable income, and you would stay at the 24% margin. What does that mean? So ultimately, I can now take 226 out every year, move it to the Roth, pay 24% tax on the margin, and take money out and put in this thing called a Roth. Now, with that same fact pattern of 2.5 million, in 9 years, if I'm taking out 226,000, I only still have 2.5 million in the IRA. So what did I effectively do? I took $2 million out of my IRA, paid taxes at 24, and now it's sitting in my Roth. But here's the catch. At 72, you're getting 100,000 in pension, 60 in Social Security, 100 is now your RMD because it's 4% of 2.5 million, not 4.5 million. Total income is 260. My new marginal rate is 24%. So any money I take out of the IRA is not going to be taxed at 24%, now 32%. In the original 226 times 9, $2 million that came out, I would save roughly about 8%, the differential between I would have paid 32% and now I'm only paying 24%. So that's roughly a savings of about $160,000. Now, the 24% continues with the IRA because you knock most of it down. So you would not be paying 32% going forward, only 24%. So again, you save money there. Then lastly, your Roth is growing. I have $2 million invested. And if that's growing, it's all growing tax-free to the next generation. So for people with large IRAs, especially if they don't need them, you have to consider a Roth. Now, we talked about a couple things here. We're using marginal rates in the last exercise, an example. But you really also have to look at your effective rate. And then you're going to have to look and see what state am I in. So, you know, depending on the state, if you're in Florida or New Jersey, that's a big difference on do you pay or you don't pay on this conversion. Lastly, what we have to look at is not only your marginal and effective tax rates, but your kids' marginal and effective tax rates. So pre-2020, we looked at your marginal rate, and let's say it was 20, 22%, 24%. And then we looked at 70.5 and said, what would it be then? And then we made an attempt to say, well, if your rates are going to be higher then, you should probably look at a Roth. But today, it's more complicated with the Secure Act. We now have to look at your kids' effective and marginal rate. And the problem here is you might not just have one, you might have 2, 3, 4, and some might be very financially successful, some will not. So in this case, I have to look at what state the kids are in, how successful they are, and what marginal rate they're in, and then come up with some conclusions. Let me give you an example. If I have a child living in New Jersey who's making $500,000, $600,000 a year, high tax payer, tax bracket person, the last thing I want to do is complicate their lives by passing away and adding more dollars into their income tax situation. So for that person, I might want them to be the beneficiary of my Roth, while I might have other kids and that might not be financially successful. Those children, I might then send my IRAs to them because they'll be in a lower tax bracket. So these are some of the things that you have to think about now when you're doing Roth planning. So what we're talking about here ultimately is what? Reducing the amount that's in the IRA. So another reduction strategy to reduce your IRA is create QCDs. Now what a QCD is a qualified charitable distribution. The law before the Secure Act allowed you at 70.5 to take an RMD, pay it to your church, charity of your choice, and not pay taxes on it. So literally you took money out of the IRA, moved it to the charity, and then pay a dime of taxes. So someone who's charitable inclined, this was a very effective way of giving money to those charities and not paying any tax on it. You could have went up to 100,000. The new law does not change that. It does not say that you have to start at 72. You can still start at 70 and a half and do that contribution to a charity and not pay taxes on it. Another way of looking at this is, let me take a Roth, and let's say in this example, if you're looking at your screen, I have 100,000 put into a Roth and then it costs me $40,000 in taxes. Well, another way, if you're charitably inclined and if you have money outside the IRA, you might want to look at the next 5 years and say, well, I'm contributing 20,000 to my church, to my favorite charity, or a combination of both. And what I like to do is take that 20,000 for the next 5 years, make it 100,000 and do it all at once. Well, if I did the Roth and it cost me 40,000 in taxes to do that conversion, I then turn around and do that contribution or donation for 100,000. And quite frankly, I eliminate the Roth taxable consequence. So now I have 100,000 going from IRA to Roth. I make my contributions, which I would have made anyway, and reduce my taxable event to zero. This act, as I stated before, kills the stretch. It is the death of the stretch IRA. As Dave alluded to before, it's going to bring in about $16 billion to the government that they never had before, most of it coming from this, which is, in the past, I could stretch that over my beneficiary's lifetime. Now it has to be over 10 years. So there's some exceptions to this rule. The first exception is spouse. So I can leave my money to my spouse, and the 10-year rule does not apply. My spouse will have their own RMD and when they take it through their lifetime. If you have a criminal, an ill person, an ill beneficiary, same thing, or disabled beneficiary, same thing, will not apply to the 10-year distribution rules. If you have a minor under the majority of a specific state, if it's New Jersey, 18 years old, and you leave money to a 15-year-old, the 10-year clock will not begin until they turn 18. So there's a few years that they don't have to take dollars out. But when they turn to majority, they have a 10-year cycle like everyone else. This particular chart I like. It's we call it the U.S. government money grab. And you can now see it in an illustration other than numbers on what's happening here. The dark line, solid line, is the old rules, which is someone inherits dollars and it's paid over their lifetime. The dotted line is the new rules, where you have to take it over 10 years. So the fact pattern with these numbers are, have someone who has $1 million and they're 65 years old. They have a daughter who's 40 years old. The client dies and the daughter gets the $1 million. Because with the new rules, she now has to apply that $1 million into her income over the next X amount of years, which we'll call 10 years, okay? So when we run this, the $1 million for a 45-year-old who gets it and has to pay taxes now over 10 years, you can see by the time she's 86, the money runs out. While in the old rules, the money would plateau around 2.5 million and stay around 2 million. There is a $2 million differential here. That's right, $2 million. Where did that $2 million go? Well, all of it, not the whole 2 million, went to the IRS. So what you gave the IRS over 10 years didn't compound over the next 10, 15, 20 years, which ate into the profits and let the money now disappear by 86. So another planning tool or something we can look at this act to sort of help us out, right? Let's give this example. On January 20th, 2020, Josh's father passes away and Josh inherits $400,000. Well, Josh is 60 years old, making $150,000 a year. He's planning to retire over the next 5 years. So what should you do here? Ultimately, we should move the dollars and leave it in the IRA, but not take it. because the current law basically says you need to take everything out of this IRA within the next 10 years. It doesn't specify if you have to take it in the first year or over 10 years, but it has to be out by the 10th year. So in this case, Josh is going to work, make an income for the next 5 years, and then retire. When he retires, then we turn on that IRA and take dollars from years 6 to 10. Hopefully, the income tax bracket at his retirement is lower than when he's working and pay less tax on that distribution. Another solution here is trying to split beneficiaries. So an example here would be, let's take a 65-year-old man who has $5 million IRA. He dies and passes this to his wife. His wife takes the dollars, and she can wait till she's 72 to start taking dollars out of that IRA. However, if the wife passes away next year after the husband passed away, the $5 million would have went to their daughter, who happens to be 40 years old. Now the daughter gets the dollars, and now the rules say you have to take it over 10 years. She goes to her accountant, and they come up and say, okay, let's take $500,000 a year of the $5 million and draw this down over 10 years. So with this fact pattern, what should have we done? Well, basically, maybe what we should have done is left $3 million to the spouse and $2 million to the daughter. And the reason for this is we're splitting beneficiaries. And then why? Why would you do this? Well, the spouse gets the $3 million, and she can wait out her time, take the dollars as she needs, and do her RMDs at 72. The daughter gets a $2 million, and because of the 10-year rule, has to start taking money into income. She decides to take out of the $2 million, $200,000 a year. So she's taxed on that $200,000. Hopefully, mom survives 10 years. The daughter would have eaten through the $2 million, paid the taxes on it at a lower rate, and now mom passes, and now she gets the $3 million. Well, now she has another 10 years for mom's $3 million. So effectively, if the pattern sort of worked out this way, you would now pay out over 20 years, not 10 years, by splitting the beneficiaries. To make this more of a numbers thing, what you can see here is the daughter inherits $2 million, and then $3 million 10 years later. If she's making $100,000 a year, and then she puts in $200,000 from the original $2 million RMD, her taxable income will be $300,000. She would be in a marginal bracket of 24%. If she took the whole $5 million up front, she would then have to take out $500,000 a year, where the marginal bracket is 35%. As you can see here, there's 11% tax shifting by using splitting beneficiary strategies. That 11% on $5 million is roughly $550,000 saved. Dave, if you can now start with life insurance.
Sure. Thanks, Rosario. Great job. So as you can see in some of these situations, there can be some significant tax liabilities due. Rosario talked about a couple of solutions. Let's talk about another solution, which is life insurance. Life insurance is a highly effective financial planning tool because basically with life insurance, what you're doing is you're paying pennies in terms of premiums to buy dollars in terms of the face amount. So the simple strategy, leaving life insurance to a trust, results in gaining trust protection, which will simulate the stretch IRA. Life insurance is tax efficient, it's income tax free to the beneficiary, and typically is state tax free if, when you issue the policy, it's issued in the name of an irrevocable life insurance trust. It's a very common document, and it keeps the life insurance from being included in part of your taxable estate. So let's walk through a life insurance strategy. Okay, you have withdrawals from IRAs at low rates and invest in a life insurance which has no RMD and no complex tax rules. So in this situation, as Rosario's talking about, you have a $2 million IRA. The approximate required minimum distribution at age 72 is $80,000. The child inherits the $2 million, and they have to distribute approximately $200,000 a year. This increases their marginal rate by 10%. That means you have an additional $200,000 in tax over that 10-year period. Simple solution, you can purchase an insurance policy for $200,000 to pay that tax, okay? Now, we had done a quick search. We represent about 150 life insurance companies. For a 65-year-old, the cost of approximately a $200,000 policy, guaranteed to the age of 100, is $3,000 a year. So of the RMD at $80,000, keep $77,000, and use $3,000 to buy this life insurance. And so what it's really going to do is it's going to cover the tax liability that your beneficiary would face, the marginal tax liability, right? The increased tax liability they would face by having this additional $200,000 per year for 10 years. So life insurance can be a very, very effective tool. Another effective tool for those of you that are charitably inclined can be charitable remainder trusts. Okay, again, you simulate the stretch IRA with yearly payouts to beneficiaries for a period of term or for the year or for their life. Now, again, you have this $2 million IRA. There's no income tax on the transfer, meaning you transfer $2 million through this charitable remainder trust to a charity. Okay, you are not taxed on that money from your IRA going into the charitable trust. So you've avoided the tax on that. For wealthier families who are charitably inclined, you leave this large IRA to the charitable remainder trusts, and then you leave your other non-qualified assets outright to your family. Those assets will get a step up in basis. By leaving the money to the charity, you can set it up as an annuity trust or a unit trust and either get a fixed payment of dollars every year or a fixed percentage of assets from the trust. At the end of your passing, the remainder reverts back to the charity. The charity's got to get at least a certain percentage of the original deposit, typically 10%, and your payout rates range anywhere from 5 to 50%, depending on how you establish the trust. This is not intended to be an exhaustive discussion of charitable remainder trusts tonight. Some other changes that we want you to be aware of in terms of the Secure Act. Okay, IRA contributions have been extended so that beyond the age of 70 and a half, as long as you're working and have earned income, you can contribute to a deductible IRA. A lot of our clients, some of whom are on this call, I know, are still working and making contributions. And so they do consulting work, what have you. A lot of our clients, retired executives, retired professionals, and can drive very significant consulting income what is essentially part-time work. And so now it's great that they can continue to make these contributions past the age of 70 and a half. Changing the kiddie tax. Under the TCJA, the Tax Cuts and Jobs Act, the last major tax law change, the taxable income of a child attributed to net unearned income was taxed according to brackets applicable to trusts and estates. The issue is that the trusts and estate tax brackets accelerate rapidly. At roughly $13,000 of income, you're at the maximum marginal tax bracket. It's very punitive, okay? Starting in 2020, the unearned income of children is taxed under the pre-T Tax Cuts and Jobs Act rules and not as state rules. So it's much more favorable on a go-forward basis in terms of the kiddie tax. There are also penalty-free retirement plan withdrawals for birth and adoption. So starting in 2020, plan distributions up to $5,000 that are used to pay for expenses related to birth and or adoption are penalty-free. Now, the $5,000 amount is on an individual basis. So for a married couple, each spouse may receive this $5,000 penalty-free for qualified birth or adoption, so $10,000 per couple.
So thanks, Dave. So you might ask, how can we help? So for our clients that are on this call, when you're going to meet us in our annual meetings, we're going to talk about what your cash flow is like, what your taxes are going to be like, and do we have to change the legal plan? Because most of you would have some the dollars in the IRAs going to trust for your kids, and you might even have created asset protection trusts. So there's changes that are going to have to be made, but we need to talk about those. For other people that are not clients, we have set aside some time in the next week to speak with you personally about these tax reduction strategies. Marissa will send you an email that you can pick a time to have a 15-minute to 30-minute discussion with Dave or myself. There's no cost or obligation to this discussion. It just helps us understand who you are and see if we can help you and if you would like to use our firm.
Thanks, Rosario. As he mentioned, for our clients on the call, when we do our significant annual review, we'll address these concerns. We'll address the new laws and how it might affect your your cash flow planning, marginal tax rates, things of that nature. If you're not part of our client community at the present point in time, Marissa will send out an email and we can walk through scenarios where we think we might be able to help. We can get a quick idea of what your existing fact pattern is of your financial life and some strategies that you might want to consider.
Okay, Dave, we're going to go now open this up for some questions, and we do have some questions. Okay, so we have a question that says, I assume the 10-year distribution requirement does not apply to an inherited IRA and that the transfer to the beneficiary prior to 2020. That is correct. So if you already have something that's been established that is already being paid out, it stays by those rules. It's for deaths after January 1st, 2020. So we don't have to worry about that. There's another question. If you started the RMD, which is almost the same question, but a different way. If you already started the RMD in 2019, do I get to move this down to 72 if I don't need it? And the answer to that is absolutely not. If you started it, you have to continue these rules of when you have to take the RMD, which is now pushed to age 72, do not apply to you, just for people that would have been 70 and a half in 2020. Another question that we have here, I have the IRAs that are not going to my kids, they're going into a trust. What happens then? Well, the trust, if done right by an attorney, they'll be considered conduit trusts. Basically, the money goes from your IRA to the trust, but the trust still looks like an IRA and would have to be stretched over the lifetime of the beneficiaries. That was the old rule. The new rule says, I don't care if it's going directly to the beneficiaries, your kids, or to a trust, you still have the 10-year requirement that you have to take this all out. Now, for folks that have asset protection trusts, this could be a problem. And what I mean by that is we put money into the trust for the kids so they can take advantage of the stretch, number one. But number two, and probably most important, to sort of help them not worry about predators, creditors, and divorce. So when we have these asset protection trusts, the dollars go into this trust. We had the stretch, and then we had the protection. So the kids took out what they needed, the RMDs and what have you, stretched it over their lifetime. But if they got divorced, if they were sued, if they went bankrupt, none of this really mattered. That trust was protected. But now these conduit trusts really do not protect the assets because they force the money out of the trust within 10 years. Thus, we pay more tax and we lose the protection. So this is what we need to sort of hone in on for most of our clients anyway in 2020. What else can we do? And there are solutions to this, but it's a little bit beyond tonight's discussion. So whoever asked that question, great question. But yes, there's going to be a little work to be done to sort of fix that going forward. Does anyone have any other questions? Let me look. No, I think that's it. With that said, this concludes tonight. I hope you got something out of this. For people that want to contact us and have questions or just want to talk to us, again, you can see our email on the right-hand side of this page. Please email us and we'll set up a time. If not, Marissa tomorrow will send out an email to you asking if you want some time with us. So other than that, thanks for joining in and hope this helped. We'll talk to you guys all soon. Take care.
Thank you.
Bye-bye.